Hello and welcome to another TLDR video. With the coronavirus dominating the news, it's no surprise that certain other things have flown under the radar. The normal things: an election here, a resignation there, a Facebook may quit Europe. Sorry, what? Well, that one was certainly unexpected. So in this video, we're going to take a look at exactly what we've got here, and whether Facebook is really going to pull out of Europe for good. If you haven't already, please subscribe to the channel and hit the bell icon. Currently, TLDR EU is racing TLDR US to reach 100,000 subscribers. The US has a big start, but the EU is catching up, and fast. So do TLDR EU a favour and help us catch up with TLDR US, and do yourself a favour by getting notifications every time we release a new video. So, what's all of this about? 2 words: data protection. Whether you like it or not, Europe has become the front runner for strong legal protections and rules when it comes to data. Whenever you've gone onto a site and got that nagging little bar telling you that we use cookies, blah blah blah, that's due to a 2002 EU directive known as the ePRIVACY directive, or more affectionately, the cookie law. More recently, rules have been tightened further with the introduction of General Data Protection Regulation, known more commonly as GDPR. GDPR has a real focus on accountability and making sure that you know exactly what and why data is being stored. You ultimately have the right to obtain access to, as well as the removal and correction of, any personal data held about you. But anyway, this video isn't about GDPR. The question is, what's this actually got to do with Facebook? Well, Chapter 5 of GDPR heavily restricts the transfer of any data collected within the European Economic Area out of it. Facebook is ultimately an American company, operating in the EU as Facebook Ireland. In order to transfer data collected by European users of Facebook, Instagram and WhatsApp from its European HQ in Ireland to its American base, Facebook must comply with the terms set out in Chapter 5. Specifically, the European Commission has to decide that the third country in question, in this case the United States, ensures an adequate level of protection, known as an adequacy decision, or Facebook itself must provide appropriate safeguards. In the simplest possible terms, transfer of data is only allowed if the data is going to remain subject to rules that are at least as strong as GDPR. GDPR is the baseline below which protections cannot fall. Given the sheer number of economic, political and social links between the United States and EU member states, the EU and US have put an agreement in place. Predating the beefed up GDPR, back in 2000, the joint data adequacy decision was reached, named Safe Harbour. The Safe Harbour Agreement promised to protect EU citizens' data when being transferred by American companies back to the US. Crucially, firms such as Facebook were allowed to self-certify that they would adhere to the relevant rules and regulations stipulated within the European Data Directive of 1995, basically creating a data-free travel zone. So far, so good, right? Well, that was until cracks began to appear. In 2011, Max Schrems, an Austrian lawyer, filed complaints with the Irish Data Protection Commissioner against Facebook, on the grounds of, you guessed it, data protection failures. Things got way worse when in 2013 Edward Snowden began to reveal information surrounding NSA surveillance practices. An issue which really picked up steam when The Guardian revealed the existence of PRISM. According to top-secret documents obtained by The Guardian, the PRISM program gave the National Security Agency in the US direct access to the systems of Google, Facebook and Apple, among other companies. This set off a chain reaction, ultimately leading to the Court of Justice of the European Union ruling that due to the existence of the PRISM program, the Safe Harbour Agreement was invalid. The CJEU specifically emphasised that the Safe Harbour regime had a number of specific shortcomings, rendering it ineffective at protecting EU data standards. Not to be dissuaded, the EU and US quickly began discussions on a revised agreement to allow data flow to continue unimpeded, culminating in the development of the Privacy Shield. As was the case with Safe Harbor, under the Privacy Shield, US companies wishing to transfer data from the EEA to the US had to comply with a set of strict obligations. Specifically, the Privacy Shield included much tighter conditions for onward transfers of data, ensuring that if data got transferred from Facebook Island to Facebook's US HQ, transferring it onto Amazon data servers for example, would again come under EU data protection laws. Job done, issue fixed. Well, no. Concerns remain surrounding whether or not the beefed up Privacy Shield actually ended up giving citizens greater data protection, with Austria and Slovenia abstaining when it came to voting, on the grounds that the agreement still didn't go far enough. Yet again, it didn't take long for the CJEU to get involved. In July of this year, the court once again ruled that the agreement was invalid, yet again on the grounds that inadequate protection for EU data was provided, and that it could not be guaranteed that EU data would be safe from US surveillance, leading to the EU's current Justice Commissioner telling MEPs that there would be no quick fix this time round. The court did, however, seemingly sanction the use of standard contractual clauses, or SCCs. These are individual legal agreements that would allow data transfers on a company-by-company basis. The issue being whether these agreements are sufficient for the individual use cases of hundreds, if not thousands, of companies that perform data transfers between the EU and US, and whether, given US data surveillance, any SCCs would ever even be approved by the EU. The striking down of the Privacy Shield led to the Irish Data Protection Commissioner, which regulates Facebook's EU activity, suggesting that he would enforce the ban, as well as block the use of SCCs for EU-US data transfers. The Irish Data Protection Commissioner reportedly gave Facebook until the end of September to contest the position, something later confirmed by Sir Nick Clegg, Facebook's global head of communications. Facebook were quick to launch a judicial review of the matter. Facebook's Associate General Counsel argued in the appeal that enforcing the ban in the way proposed by the Data Protection Commissioner would leave the company unable to operate in Europe. In a sworn affidavit obtained by Vice, she stressed that in the event that Facebook was subject to a complete suspension of transfers of user data to the US, it's not clear how, in those circumstances, it could continue to provide the Facebook and Instagram services to the EU. The consequences of this are likely to be significant and wide-ranging to Facebook and the millions of individuals and businesses who use its services in Europe. She also highlighted the economic benefit of Facebook in Europe, notably that some 25 million businesses in Europe use Facebook, and that the company generates billions of euros in advertising revenue. But following the debacle over in the United States when it comes to TikTok, is Facebook really about to pull out of Europe? Well, no. After the affidavit came to light, a spokesman for Facebook stressed Facebook is not threatening to withdraw from Europe. Legal documents filed with the Irish High Court set out the simple reality that Facebook and many other businesses, organisations and services rely on data transfers between the EU and US in order to operate their services. Something stressed again by Nick Clegg, who said that we have absolutely no desire, no wish, no plans to withdraw. Why would we? However, we are clearly not able to operate as we do, and nor will many, many other companies, if one moment to the next, the existing legal provisions which govern data transfers from the European Union to the US and other jurisdictions are suddenly removed. So while Facebook isn't set to quit Europe, for now at least, this does raise questions about the future of American tech giants in Europe. While this ruling and debate focuses primarily on Facebook's operations, the likes of Google and Apple will be invariably affected by the fallout of the final outcome. What the future holds is anyone's guess. Be sure to subscribe to the channel and hit the bell icon to be notified when we release further videos like this one. Special thanks to our Patreon backers who make our videos possible. If you want to see your name at the end of videos, just like Callum Johnson, Carol Kwan and Stefan C, then be sure to back us on Patreon. The link to that's in the description.